Good afternoon, everybody. My name is David Gallo from the AIFC Academy of Law, and we welcome all of you from across the globe. We have the next segment of our webinar on enforcement today. And introducing the speaker will be my good friend and colleague, Professor Dr. Alexander Van de Putte. Alexander, please.
Thank you very much, David. And I will be very short, and for actually two reasons. It's not the first time that Mike has spoken to you on this very topic. So he introduced previously Module 1 and Module 2 of the Introduction to Enforcement. Number 2 is I have jury duty. I'm actually on a jury to evaluate about 20 projects of the Leadership Lab. And so I will have to leave shortly. But it gives me great pleasure to introduce a colleague, Michael Howard, who is currently in the United Kingdom, actually in a place that I visited many times, which is called Hastings. And you probably all remember this from 1066, the Battle of Hastings, the French and the Brits that confronted each other, and unfortunately for the Brits, it was the French who won the battle. Now, let me not go back that long, but actually let us bring us to the topic of today. So it's an introduction to enforcement, and more specifically, Mike will talk about Module 3, which is the discipline process. I guess, Mike, there are no carrots here. It's all about sticks. And when we look at Module 4 is investigations and its process, so it's opening, planning, and conducting. Mike, I hand over to you. You're the expert speaker here. Obviously, Mike works with AFSA, our independent regulator, where he is the head of the enforcement division. And sorry, I cannot stay with you for the remainder of the session, but I wish you a very good session, and David will close it at the very end. Thank you very much. See you soon.
Thank you, Professor. Okay, before I start, I'll just recap a little bit on what I've said before. I think you're already aware that matters are referred to enforcement in a number of ways. The main one is from supervision. And once it's received, it's reviewed by enforcement, by an investigator who will report, make some basic inquiries and prepare an assessment report. Now, the purpose of this assessment is to form an impression as to whether the matter is serious enough to go into the discipline process, which is what I will discuss today. The assessment report is presented to the Enforcement Committee, and the Enforcement Committee is a group of directors who are independent of the investigation for very good reasons, for reasons of transparency particularly. And they will make the decision as to whether a full investigation is warranted. At the end of the day, once they make that recommendation, we embark on the discipline process. So next slide, please, Jeff. Jeff, could I have the next slide? Thank you. Okay, so the Enforcement Committee reads the report, and if they decide that there is some misconduct or there are reasons other than misconduct that they need to start an investigation, they will instruct a full investigation. And that is the starting line, if you like, for enforcement division, because that is our role. We will conduct the investigation, we will interview all parties to the investigation, we will ask for documents to support, and we will create an investigation report. Next slide, please. This process is incredibly formal, and the reason for this, and my main message for this presentation, is that once the decision to commence enforcement is made, it is an incredibly long, complex, and very rigid legally procedure. If we do not take every step according to the legislation, then we can be subject to appeal in the AIFC court. So the investigators are formally appointed. It's done in writing, and once the investigators are appointed, a copy of that appointment will be sent to the person under investigation. The size of an investigation team, or the number of investigators appointed, will vary immensely, and it depends on the nature of the investigation. We may need subject matter experts. There'll be a minimum of 2 investigators, but we may also need technical consultants, such as IT consultants for recovering data. So the firm is informed, or the individual is informed. That is the first official formal step. Now, we do not publicize the start of an investigation. So everything that occurs throughout the investigation remains confidential. Next slide, please. The first thing the investigators do will prepare an investigation plan, and this lays out the key areas to investigate. The scope is incredibly important because this will include limitations, the initial direction of the investigation, timelines, and discussions between myself and my team about the investigation. We can also request or demand, actually, compel documents to be produced. So if we require documents to be produced, we have to submit a formal letter and time to do that on the firm or the individual. So that we then have to examine those documents, and based on the allegations and the documents and the evidence we have, we will make a decision on which staff will need to be interviewed. Next slide, please. The interviews can be of 2 types. Usually when a person is subject to, is a person of interest or subject to enforcement proceedings, we would compel an interview. And we are able to do that under our current legislation. So we would forward a document to that person, informing them that they are compelled to attend an interview. They're allowed to have a legal representative if they wish. And there was always a minimum of 2 investigators present. And obviously we also have to take cognizance of other factors, such as the sex of the person we're interviewing. So 2 male investigators would not interview a female person of interest. You would have to have a female present. It's things like that that just increase the transparency of the system. The second investigator, mainly, the lead investigator will lead the interview, but the second investigator will take notes. We do record interviews, and the recording can be compelled. However, if the person being interviewed's legal advisor refuses to be interviewed and recorded, then we will have to do it the old-fashioned way and write down the replies. Obviously, this takes a lot longer. Next slide, please. We then provide a transcript of the interview to the interviewee. And obviously for that purpose, during the introduction to the interview, all people present would introduce themselves and the transcription would then reflect who was saying what. Now, the person who was interviewed can make some typographical amendments, but not anything of substance. And if they later fight what they said, then it is within their rights to appeal to the AIFC court. Now, once you've completed the interviews in an investigation, obviously, sometimes, actually quite often, further areas are identified that need to be followed up. And these can be areas that you weren't aware of when the investigation commenced. So it is often necessary to require further production of documents in connection with the investigation. Next slide, please. If there is a huge amount of computer evidence, now investigations I have done in the past, we have required a computer forensic firm to image all the computers in a bank. Now, as you can imagine, that is a huge task and requires specialist assistance. So we actually need to have access to those resources to be able to do that. Each investigation is different, and not every investigation requires that amount of resources. The important thing is that as the investigation progresses, myself, the director, needs to be informed of progress, and we need to amend possibly how the investigation goes forward based on the data and the information we have. Next slide, please. So once we've completed the investigation, or at least the investigation into the salient points, i.e. the contraventions of law, we have to show each contravention, and we have to detail factually the evidence that supports it and who can provide that evidence and how that evidence is provided. This report is probably the most important document, and also contains a conclusion, which is an objective view of the facts, and a recommendation, which is somewhat more subjective potentially. And that is why, once the report is completed, next slide please, the enforcement committee is reconvened. Again, the enforcement committee is totally independent of the investigation, and they will be given the report, all supporting documentation and all supporting evidence. They have time to consider it, and then they have a not an enviable job, I must say, but they must consider the whole circumstances of the issue. And that includes the weight of evidence, supporting documentation, the verbal briefing from the lead investigator, and also the political effect of the AIFC, and actually many other factors which they have to take into account. Next slide, please. So once this is presented, they can do one of many things. They can take no action. Okay, if the investigation report does not satisfy them that offences have been committed, they can take no action, or they can ask for more information. They can also give something called a private warning, which is a watered down enforcement action, whereby it's not too serious, but somebody gets a private, basically a slap on the wrist, warning that if they do this again, it will be followed up seriously. The main thing they get to recommend is the imposition of a financial penalty, and all of you will have seen ridiculous financial penalties imposed all around the world. Just to quote an example, a brokerage in the US was just fined $15 million US for a lack of money laundering governance. They can also vary or impose restrictions, so the enforcement committee can decide that somebody should not act as a manager or an approved individual, or they can appoint somebody as a manager to take over the functions, to bring the firm into line with the AIFC law. They can prohibit people from a controlled function, or there can be a settlement, an acceptance between the parties that if the matter is settled, the party will take measures to control what they've done and put in measures to prevent it happening again. And then the regulatory body, i.e. AFSA, can accept a smaller financial penalty than might otherwise be warranted. Next slide, please. So the next stage, if the enforcement committee decides that action should be taken, and action should be taken on a firm or an individual, we must notify the firm or individual in a document called a preliminary notice. Again, this is all subject to court appeal, so it must be done correctly. This notice contains a summary of the contraventions, all the evidence, and explains the firm or the individual's rights and the procedural issues in terms of things like third parties. This notice then gives them 28 days to make written representations. Now, these representations are very important because if the regulatory authority says we are going to fine you 200,000 US, their representations as to why we should not do this are obviously very important. Next slide, please. Thank you. So we will summarize the representations, and then we draft a second document, and that is called a decision notice. This again goes back to the enforcement committee, the independent committee, and they will consider the decision notice in light of the representations. And they may decide, if the firm has valid reasons, that discipline action should not proceed. Or they may say, okay, the firm has not satisfied us that it's going to make any changes, so we will proceed with the action. That decision notice is then served on the firm as a final decision. And once that is served, the firm or individual has another 28 days to either accept it, make a settlement, offer a settlement, or appeal to the AIFC court that the decision made is unfair or should not be applicable to them. Next slide, please. So, as I said, the decision notice includes all the findings of fact, the date on which it will take effect, and the date on which any action must be taken by the firm or individual. And obviously they have a right to seek the appeal. Next slide, please. If they do appeal, this creates a huge work issue for enforcement, because we have to prepare for a full court hearing, which means going back and going over the interviews and getting witness statements and people who can give actual evidence as to the documentation and its validity. I've only been involved in one such decision, but it was almost 5 months full-time work for an enforcement group of 7 people. So it's quite a lot of work, but of course the people have the right to appeal, and we just have to deal with that. The appeal has to have some grounds. Ultra vires means acting beyond legal authority. So if they think our fine, for instance, is unreasonable or illegal, it can be made on an error of law. If they think our evidence does not support the contraventions, unreasonable, not made in good faith, or not proportionate, and that's quite an important one, because it is important for the whole of the AIFC that what we do is seen to be proportionate. And I can go on later to explain about how we achieve that. Next slide, please. So once the decision notice is served, after 28 days, if they don't appeal, we can publish it. Now, the reason we publish decision notices is twofold. It's one, principally to inform the AIFC community that should people contravene our law, we will take action. And the second is to reinforce to the public that we are an effective regulatory body, and we do look after the interests of clients and shareholders in companies. Next slide, please. Now I'll move on to investigations, which is actually way more my field, as most of you are aware. And in this section, I'll cover the stages of an investigation, because most people are not aware of how complex most investigations are. I'll cover the general process, how we plan them, briefly appointing the investigators, sorry, the various powers we have, dealing with non-compliance with those powers, and the importance of the investigation report. And at the end, I'll briefly cover how we assist overseas regulators in conducting investigations within the AIFC. Again, I'll also briefly mention the costs of the investigations, because one of the unique facets of the AIFC is that when we conduct an investigation under the Financial Services Framework Regulations, we are able to actually charge the people we investigate and recoup the costs. First slide, please. So once we're told about the investigation, and I've been through this, so I'll skip through it very quickly. The investigators will be formally appointed. Obviously, we will take into account whether there are any previous conflicts of interest, such as past dealings or with the subject of the investigation. And we will keep the team free of conflicts. And we will also mix the team according to their skill sets. So it's not, it is quite likely that we will have somebody from legal, for instance, on the team to assist us in a particularly complex case. Next slide, please. So we always warn somebody that they are under investigation. This is done by way of a copy of the appointment of investigators and a covering letter with their rights. And of course, if we subsequently, at any stage, decide to drop the investigation, which does happen through various reasons, we will notify them that we have stopped the investigation. That's reasonable, and again, it's all part of the transparency that we strive for. Next slide, please. So the team will be led by a lead investigator who is nominated, and that person will take charge of the investigation. They will review initially everything that is known about the subject and the reasons behind the investigation, the content of the assessment report, obviously, which they will have been involved in preparing, and other supporting documents. We would also do open source investigations, an examination of various documents held by departments such as registration, authorization, in relation to the subject firm or the subject individual. Next slide, please. At the beginning of the investigation, it's really an investigation is an organic thing. It's very difficult to describe, but you have to ask yourself a number of questions because each investigation is unique. And has different personalities involved, goals, methods, outcomes, and even politics come into it. So we must focus on what our main goals are. And the way we do this is we have an investigation plan, and this is updated weekly depending on how the investigation is going. But the sort of questions that we need to ask, I'll go through some of them so you're aware. What do we already know about the matter? What are the elements of the contravention? Who is involved? What sources of evidence are there out there that may assist us? Are there any overseas parties or overseas interests? How easily available is the evidence, or do we need to focus on using other resources to find it? What action has already been taken? How much money is involved? What is the misconduct? When was it? And is it going on during the investigation? Because obviously we have to take steps to stop it once we're aware of it. I'll come on to that later. Is there any risk of loss to third parties such as clients or shareholders, customers? Is there any risk of assets being dissipated or evidence being destroyed once they're aware that there is an investigation? Should we take any urgent action? And sometimes this is incredibly important. We may need to take action to freeze assets or prevent people leaving the country so we can interview them. should the facts be made public? Sometimes during an investigation, when people are still being, if you like, defrauded or scammed, we need to inform the public that this is going on. So that is another aspect. What are the key areas? Should we prioritize any one area? Are there other agencies involved? Another issue we have to take into account is there anything to suggest that criminal offences are being committed? We also come up against legal or technical issues. Another question, what is the probability of success in our investigation? Because there's no point putting all your resources into a huge investigation if there is no chance of success. What is the appropriate outcome? What difficulties will we face? And that will become apparent as the investigation progresses. And how should roles and responsibilities of the investigation team be allocated? There's also what effect will this investigation have on other matters that we're currently dealing with? And of course, at the end of the day, there are also cost considerations. So whilst every investigation plan is unique, you have to ask all these questions before you even form your plan. And once you form your plan, although it's unique to a particular case, next slide, please. You have to take these things into account. So first of all, talking about the scope. This is the foundation of the investigation. So it's the rationale of the case, the objectives, the strategy, inclusions, what you can include in the investigation, exclusions, what you cannot include, related projects, assumptions, constraints, and unknowns. So a whole wealth of different stuff. Second one, costs and recovery. Effective investigation planning must include a process whereby if we are able to recover the costs, we have to be able to justify them. So this will include external costs such as lawyers, transcription of interview, technical IT intervention if required, but it also requires a breakdown of hours, investigative hours. So we have to be very aware of that. Tasks and time. Now, time management is one of the most important processes because an investigation can go off at all sorts of tangents. You have to keep it focused and keep people in control of their time. And that's why key tasks need to be scheduled to be completed, and they need to be completed on time. The quality management. Now, we obviously need to apply normal objective standards and processes to achieve that. And we have to manage all the stakeholders involved with an investigation. And that includes the people being investigated. Any enforcement action does affect the rights and liberties of other people, any enforcement action. And it's very important that what we do is transparent, open, and the frequent source of legal input to make sure we are on the right track. Insofar as it's able to, we'll move on to risks. As you progress in an investigation, you will come across different risks. They might be known, they might be potential, but they might have an adverse effect on the case itself, the investigation itself. And where we identify risks, obviously we need to mitigate them. So that is yet another issue that the investigation will throw up. Resourcing, obviously very important, but that's the responsibility of the lead investigator with myself, who consider at the outset what resources we think will be sufficient to progress the matter as quickly as possible. And yet, we may need the multidisciplinary team, which would speed up the investigation with their subject matter knowledge. Communications, obviously very important. We need to not only communicate between the investigation team internally, but outwardly to senior management, stakeholders, and the people under investigation. We need, one of the key things we need to do is have effective decision making to ensure that the investigation is on course and will meet its objectives. And the miscellaneous bit relates to any other aspects of the case that have a material bearing on the direction. And obviously, halfway through a case, we can find out information such as through a bank account, for instance, that sends us on a whole different path, potentially something like money laundering or fraud or something else. And that also may require urgent action. So that is just the investigation plan before we really start. And it has to take into account all those factors. So the point I'm trying to make with this is that there is no time limit for any investigation. It has to be organic, but it has to be monitored and managed very closely and on an ongoing basis. And this plan has to change as the investigation matures. Next slide, please. I've briefly mentioned urgent action before. In some cases, it will be necessary to take urgent action, and that could involve notifying other authorities, overseas regulators. Should we just knock on the door and do an unannounced visit? We have the power to do that. However, we would rather not, because that appears a bit over aggressive. We do need to obtain a court order if we need to freeze assets. So that is certainly one of the options. And we also need a court order to prevent somebody leaving the country. So that is a consideration for urgent action. The IT issue is quite important. To get an IT company to fly in, because there's not the international level of expertise currently in Kazakhstan to do this. So we probably have to fly in an outside service provider, and they would seize all the computers, image their contents, give them back, and they can actually preserve and set up all the data for investigation. And they can tell if stuff has been deleted. That will all be available. So obviously that's an important consideration for urgent action if we were investigating something like a bank or serious misconduct in a bank where the email messages and the bank records are all on IT systems. Once we seize documents, we have to consider transport and storage. And that's another issue that will be done on a case-by-case basis. And of course, if there's a risk of the people we're investigating destroying evidence, then obviously that is something we need to stop or prevent or try and prevent. Next slide, please. Okay, so in investigation, I would have weekly meetings with my team. We would discuss the case I would discuss the case with the lead investigator and the other investigators. It may be that I need updates in writing for senior management, and they would need to contain a number of issues. But these would include major breakthroughs, changes in direction, new persons of interest who may have come up, or new evidence. Next slide, please. The powers we have under the FSFR are very strong, actually. So we can require a person to provide information. We can compel a person to attend interview at a place we specify. We can require information to be produced. And we can actually walk into a business to inspect and copy documents. So our powers are fairly sweeping, I would say. Next slide, please. These are other powers we have. We can require a report. If we're not happy how a company is running, we can require the company to provide an independent report on their activities. Obviously, we at all times have the power to go through the court in cases of non-compliance, but non-compliance with our powers are a contravention of AIFC law. So the individual or firm who is not compliant can be fined or given a financial penalty or other penalty for not complying. We can force an individual or a firm into an enforceable agreement. This is a mutual agreement that they will do what they need to do, and we will give them time to do it, and if they don't, they will be subject to further penalties. We can stop them doing business if we feel that their transgressions are so serious that this is the preferable option. And obviously the main one is the dissipation of assets. If people have been stealing from customers or laundering money and they have money in their accounts, we need to stop them being disposed of before the investigation is completed. Next slide, please. So when we interview, we have two types of interview. We can compel, or generally with witnesses, we would use the voluntary interview because this is less combative or aggressive. The compelled interview solidifies our legal position and would be used in cases of persons of interest who we suspect have contravened the AIFC law. The timing of an interview is quite important. It's not acceptable to do the interviews late at night or for extended periods. At the end of the day, the interview may need to be acceptable in court at an appeal. So we have to be very cognizant of that. The length of an interview that can vary. I have interviewed for 9 hours when the interviewee has agreed, but my own personal limit will be 6 hours and a break in the middle for comfort for the interviewee. Compelled interview, they are allowed to have a lawyer as they are with a voluntary interview, but they can't have random other people such as friends present. We always record interviews because we then provide them with the transcript, and that transcript can then be used to formulate a statement should the matter ever go to court. Obviously, the language is principally English. It's an international financial center, but we do have some difficulties in some of the staff, and some of the people we deal with will not speak sufficient English. So we would need to utilize translators to get a statement in English. And of course, proceedings in the court are all in English. The chief difficulty at an interview is putting documents to the interviewee. And the difficulty is that I've put 120 documents, and the interviewee has to look at the document, accept its contents, and then it has to go into evidence. So you put their initials of their name and document 1 to 100 or whatever. But that is a very time-consuming process. And as I've said, some interviews I've done over 3 days. But I don't prefer going over 6 hours per day. Next slide, please. When people don't comply with turning up for an interview, it is a contravention, so they can actually be served a preliminary notice and a decision notice based on that, and appropriate discipline action can be outlined in those notices. But we do have to also take into account they may have their own reasons for not complying, and can we get the information from somewhere else, or should we go the court route, which would cover us in subsequent proceedings. So there are a lot of different approaches we can take to non-compliance. Next slide, please. The investigation report, when it's completed, is the basis of all subsequent action. It's a very important document. We often peer review it before it's submitted to the enforcement committee, and peer review means we often give it to all the other investigators to see if they see any flaws in the document, because the document must be factual, objective, and supported by evidence. Those are the three principal things that make the document such a key document. It needs to provide a thorough analysis and evidence supporting each individual contravention that we would be able to prove in court. Next slide, please. When we assist overseas regulators, we do have a big duty to assist them. We're in a number of memorandums of understanding with a number of organizations. And if requested by them, obviously, we will assist them. We may share confidential information. However, there are some restrictions on information that may lead to criminal proceedings, which we are very aware of, and so are the overseas regulators. But generally, we will work with them. We will even allow one of their interviewers or investigators to attend interviews if it benefits the investigation as a whole. It's a very grey area because we haven't been involved with this side of it yet. I have interviewed people in my previous role in Europe with regulators present, and it does complicate issues, and there are issues we have to take into account about personal information and the divulgence of the interview information to the other entity. So that's quite a complex area, and that's one where I would almost certainly use the assistance of legal in, because that's where they could be very, very useful to make sure that we did not step over what we are legally obliged to do. Next slide, please. Thanks. And my final point, I'm just coming to the end. I want some time for questions, if that's okay. We can, under the Financial Services Framework Regulations, recover costs, but we would only do that in a, what I would call a serious event. In my last case I did, in my previous regulatory role, we fined a firm $1.4 million US, and we fined the directors individually $200,000 US each for a lack of governance. But because their transgressions were serious, we also applied that they paid costs of the investigation, and that was granted. So it's preferable, and we would definitely go to the court to make sure that they ratified that the costs were correct. And as you can see, that covers the costs for legal counsel, consultants, IT experts, transcription, travel, courier costs. We often have to travel to other countries to interview. In my previous role, I traveled to 5 or 6 different countries to interview witnesses and people involved. So that's the end of my, I'm sorry to pack it in so quickly. That's the end of my presentation. If anyone has any questions, I'm very happy to answer them.
Thank you, Mike. I believe Almas has been soliciting some written questions coming in. And Almas, I believe you have a few, correct?
Yes, thank you, David. We've received several questions. So the first question is, what is the main differences conducting an investigation under the AFC Financial Services Framework Regulations and the company regulations?
Right, the difference there is that normally the enforcement committee will start an investigation under the Financial Service Framework Regulations. However, the registrar in his own right under the company's regulations can appoint investigators, and the difference is that when he appoints them under the company's regulations, the investigation goes through, the investigation report is completed, and it's then sent to the registrar for what action he deems necessary. The other issue with that is that under the company regulations and company rules, many of the statutory duties of a company have a maximum fine limit. And this is mainly to do with technical stuff like submitting returns or not having registers, or so the difference between that and the financial services framework is that there is no limit to the amount that can be fined. So I hope that helps.
Okay, thank you. The next question is, what kind of disciplinary sanctions and fines for contraventions AFC can apply to company or persons who has breached of AFC legislations?
In our policy, we have a lot of criteria which the enforcement committee have to apply before reaching a decision as to the amount of financial penalty. What we do in effect is we canvass worldwide regulatory authorities, and we provide benchmarking to the enforcement committee about what is reasonable on a worldwide basis and with other international financial centers. We then have to moderate that somewhat because we are emerging, we are new, and we have to also gauge or be aware of the effect on participants in the AIFC. So there's a whole host of factors, but at the end of the day, the enforcement committee will come up with a figure. And then the firm who's been fined or the individual can give his representations. If they're reasonable, they can drop that figure. So really, it's a benchmarking exercise with norms around the world.
Okay, thank you. The next question, in addition to this question, really in relation to fines, if the AFC considers that a regulated company or persons or non-regulated has committed a contravention, it may be punishable by fine. The amounts of fines for the offenses may impose on them. How the AFC will calculate it?
As I've said, we benchmark with similar offences with similar companies around the world, and then we have to put it in context for Kazakhstan. And we also have to be aware you can't fine a firm that's going to bankrupt it, because we're encouraging firms to come here. So you have to find a happy medium between a fine that will cause them to stop and think, but will not stop them functioning. And we can achieve that. It's just a matter of communication.
Okay. And the last question, also in relation to fines. If the amount of fines is too high or considers not appropriate in respect of the contravention, will it cause an outflow of investments from Kazakhstan?
I don't believe it would, because if the company thinks it's too high, they can appeal to the AIFC court, and they're quite open to do that. And to the other companies, it's very important that their clients and customers know that our focus is on looking after their interests. Shareholders, clients, customers, whatever. If the firm is not being governed in the right way or is not operating in the right way, it is important that people are aware. So no, I don't think that sends a negative message. And I don't think we will be over-fining, because obviously we then risk litigation in the court.
Okay, and considering the timing, I propose to have one more question. Sorry, David, just one question. In some states, for instance, Estonia, Hungary, and Latvia, the bailiffs has a monopoly on the enforcement of court decisions in civil cases. What about AFC court decisions? Is there a monopoly for local bailiffs?
Sorry, can you say that again, please?
In some states, the bailiff has a monopoly on the enforcement of court decisions in civil cases. What about AFC court decisions? Is there a monopoly for local bailiffs?
The AIFC court can decide, based on English common law, all issues within the AIFC. Now, we also have to consider Kazakh state law as well, the republic law. And this is where, although untested yet, this is new ground for us. But for instance, if I'm investigating a case and I believe they've broken Kazakh law, the state law, then I would have to inform law enforcement within Kazakhstan. Now, my investigation will continue independently within the AIFC. So I would say at the moment, this is not tested, but as far as I am concerned, the AIFC deals within, the court deals within the AIFC.
Okay, so we have finished with the questions.
Yes. Okay. Thanks so much,
Right.
Alma.
Thank you.
Mike Howard, on behalf of the Academy of Law, we really thank you for your time today in delivering a highly relevant and obviously a very well-informed presentation on the topics of investigations and the disciplinary processes. Mike, you're welcome anytime to come back to this platform. We hope to see you again. I wanted to just make a couple of concluding remarks by way of reflecting on what you've heard today. The context is this. Remember, the AFSA is the Astana Financial Services Authority, and that authority is the regulator for financial services companies who have registered within the AIFC jurisdiction. So those companies obviously are bound to comply with those regulations. And to the extent that there may be a circumstance that justifies an investigation, what we heard from Mike Howard, the head of the enforcement division, is he gave a description of the considerations during an investigation, how an investigation is structured, and how findings from that investigation may be amended in light of new information that is discovered or that comes in. And then to the extent that the facts indicate that in fact there was a contravention, well, then there's a disciplinary process and disciplinary standards that are applied as I suppose, the consequences of the outcome of the investigation. So Mike also provided us with a description of the full discipline processes that a regulated firm could expect if in fact misconduct or a contravention of AIFC regulations is discovered. So that keeps it all in perspective. To all of our participants, we want to thank you yet again for joining us today. We hope to see you again in our future learning and development activities. We have a very exciting agenda of programs that we're rolling out over the next several months. So please stay tuned, stay safe, stay positive, and all the best as you continue to move your law firms or your companies forward during these unprecedented circumstances. So thank you very much. And Mike, thank you again.
Thank you, David. Goodbye.
Bye, everybody.